Okay, we are live. I'm attorney Vincent Davis. It's Sunday morning, and this is The Secret: How to Fight CPS and Win. Um, we had a guest scheduled today, Michael, and he is having some technical difficulties right now. So what I'm going to do is I'm going to do a little improvisation. I'm going to play some videos that I have made before, giving you some pointers and some tips on, the aspects of having a CPS case in the state court system. So I'm going to play some of these videos, then I'm going to come back. And if you have any comments, go ahead and post those comments or those questions, and I'll try to answer them afterwards, after we play these videos. Okay, stand by. I was recently asked a question, and it was a very interesting question. A caller asked me, Vince, out of all of the hundreds of videos you've done on YouTube, what's the single one most important YouTube video you have done? And I thought long and hard about it. And it's probably a video I did, it seems like a year, 2 years, 3 years ago, maybe. And the name of the video is, What is Justice? I think that everyone who has a CPS case or has any type of case in general should watch that. I think it's about a 7-minute video where I'm standing in front of a whiteboard explaining what is justice. Justice isn't what you think it is. Please watch that video and educate yourself so that you will know how to deal with this judicial system and your CPS case. Trial is fast approaching. Are you and your attorney ready for the trial? Have witnesses been subpoenaed? Has exhibits been subpoenaed? Has the witness list been prepared? Has the exhibit list been prepared? Have the trial briefs been prepared? These are all questions that you need to know the answer to before you go to trial in any CPS case. CPS cases are just like other cases. There should be preparation, and you should sit down with your attorney, either in person, by phone, or Zoom, or something like that, and discuss the strategy for your case. Don't wait until the day of the trial to talk to your attorney. Be proactive. Contact your attorney by phone, text, email. Talk to your attorney. These are your children that we're talking about. Make sure that you and your attorney are prepared. Ask them, have the witnesses been subpoenaed? Ask them, are the exhibits ready to go and be introduced? Call me if you. In California, hearsay rules of evidence in juvenile dependency or CPS cases is different than a regular criminal case and different from a regular civil case. For whatever reason, the California Supreme Court and the legislature of California has ruled or made law that hearsay used by a social worker can be used against you in a proceeding. The reverse is not true. You are not allowed to use hearsay in a proceeding against the social worker. Now, there are a lot of exceptions to the hearsay rule, and in California, there's hearsay, which is an out-of-court statement used in court to prove the truth of the matter therein. There are many exceptions, but when you're coming to lay out your case and strategize your case, remember, you have to fall under one of those hearsay exceptions in order to use that important evidence. Call me if you have questions. Let me give you some tips on how to talk to your prospective CPS attorney or even your CPS attorney when you speak to them in person or on the phone. The first thing you want to tell them is not a story of your case. Do not tell them that. Put a fence around the story of your case before you tell the story. Be ready to tell the attorney the posture of the case, where you're at in the case, the next court hearing, and what type of hearing it is. And then, if he or she has the time, you can tell the story of the case. A lot of times, the story has no impact on the different phases of the case. I know that sounds strange, but each phase in a CPS case is different from the previous phase. So what happened 2 phases ago may not be relevant now. Call me, 888-888-6582. All right. These are my detention hearing tricks. Your first hearing before the juvenile court in a CPS case. The one thing that you have to remember is you have to remember to argue and to show that the social worker did not offer you services in order to prevent the detention and placement of your children in a foster home. The social worker has to prove two things at a detention hearing, at least in California, and I would guess in other states, but check with your attorney. The social worker has to show that you're some type of substantial risk to the child. That's pretty hard to do, especially if this is a one-time incident or the problem has been resolved. But the other thing they have to do is they have to show that they offered you services that would prevent detention. Talk to your attorney before going. Okay, here's a tip for the jurisdictional hearing, which is generally the second and or the third hearing in a CPS case here in California. At the jurisdictional hearing, the judge must decide if the allegations the social worker has charged you with are true or partially true. If they're not true, the case is thrown out. If they are true, you proceed immediately, in most cases, to the dispositional hearing. Sometimes the jurisdictional and dispositional hearing are done together. But here's the tip. The important tip is before you go to court, maybe a week, 10 days, sit down with your lawyer on the phone, on a Zoom, in person. Come up with a strategy for the jurisdictional hearing. You might want to discuss witnesses that need to be called. You might want to discuss documentary evidence that needs to be subpoenaed. Sit down with your lawyer and make sure that he or she is ready with you for this important jurisdictional hearing. Okay, the topic of minors testifying in CPS cases is always an important topic. These are the things that you must consider. Number one, is the minor competent? In order to testify in California, the minor has to reach a certain level of competency, usually in the ability to tell the truth and to discern truth from falsity or truth from, for example, daydreams or night dreams. Sometimes I've had minors testify that say, oh, they dreamt something, and that's maybe not going to allow them to be competent to testify in a trial or in a hearing. The other thing they have to do is they have to be able to understand the difference and the consequences in taking the oath, the promise to tell the truth, the whole truth, and nothing but the truth. You'd be surprised, a lot of minors don't understand that particular consequence. So call me if you have questions. Okay, I hope those video shorts, those are YouTube video shorts, helped you. We were showing those this morning because our guest, Michael, was having some technical difficulties. If you have any questions or comments that you want to post, go ahead and post, and I'll be happy to go ahead and answer that. And I'm working with Grace, our producer. We're going to turn this live stream into something like a call-in show where you can call in and ask your questions instead of just typing them in the chat. I want to tell you one thing. I'm preparing for a trial next week in CPS court in a county here in Los Angeles, and it is a hearing after 6 months after the disposition hearing. So it's called a 6 month review hearing. And one of the things that I'm dealing with right now is trying to get my client to understand a few key concepts. I got on the case late for many reasons. She was represented, I believe, by a court appointed attorney initially. And the court appointed attorney did the detention hearing and did the jurisdictional and dispositional hearing. Now, at that hearing, she lost, and certain orders and findings were made, contrary to my client's beliefs about what the true facts were. Here's the problem. When I take over the case at the 6 month hearing, my client wants to tell me all about what happened during the detention, the jurisdictional hearing, the dispositional hearing, and how her rights may have been violated when the child was initially detained. Now, all of that can be interesting if I'm doing the appeal. However, I'm not doing the appeal. She waited too late to file for an appeal. All of that could be interesting in a civil rights case against the social worker. But we're not talking about a civil rights case right now. We're talking about a 6 month review and trying to get the child back in her custody. So she's talking about hearings one, two, and three. I'm talking about hearing four. Guess what? We're not on the same page. We're not having a meeting of the minds. And it's taking a lot of time for me to show and convince her that what I'm saying is actually true and in her best interest. And that is what's happened since the dispositional hearing to the present date, that 6 months in between. So, what has happened? Now, here are the things that are important for what has happened if she wants to get the child back into her custody. Number one, has she been visiting the child, and have those visits been good and quality visits? I saw a trial not too long ago where a parent did not get the child back because the parent had decided not to visit the child. Now, I wasn't on the case. I was just watching it, waiting for my case to be called. But it was interesting in listening to the judge. And sometimes we forget one of the most important services that you can participate in is visitation with your child. So when you visit, make sure you visit often, make sure that it's a quality visit, and make sure that your child is enjoying that visit. Now, a lot of people have problems giving information or having a good visit. And someone that was a client of mine who is also on social media has come up with some plans of how to have a good visit. And it's interesting because as a parent who had a CPS case and who did visitation and who talked to other parents about visitation, she's come up with some very good ideas. So if you're interested, drop me a line at v. Davis at Vincent W. Davis, and I'll try to connect you with her or give you some videos where she talks about how to have good visitation with your child. The next thing is you got to make sure that you've done the services. We're at the 6 month date. The judge ordered you to do some services. You didn't appeal, or you appealed and you lost. So that's become the focus of the case, what the judge has ordered. Now, here's the bad news. It doesn't matter what you thought happened in hearings one, two, and three. Okay? Those hearings are dead. They're over. The judge has made findings. Can you go back and change it? Theoretically, you can, even if you miss the appellate date. There's certain types of motions and writs that you can file. However, they don't have a high probability of success, especially in the juvenile courts arena. And by the way, if you do that, you may further damage any type of civil rights case you have after the juvenile dependency case. So let's just focus on what the judge has done. Make sure that those witnesses that have provided those services to you have written some type of letter, if possible, or a completion certificate, and they come to court. They're available to come to court to testify. Because what usually happens is mother does everything, and then there's just one thing, the individual counseling. And the social worker writes in her report and testifies at court at the 6 month hearing that mother did do counseling. However, she didn't get anything out of it. She was just sitting there as like a bump on the log. She never internalized it. And generally, your therapist doesn't say these things to the social worker. Generally, the social worker is determining this on his or her own. Now, how they determine it, I don't know, because generally, in 99% of the cases, they're not qualified to say or give an expert opinion about whether you got anything out of the counseling with a licensed therapist. They're not therapists. Sometimes they are, though. And then sometimes they interview you and they report back to the judge, well, based upon the interview, blah, blah, blah. Mom hasn't gotten anything out of this. She hasn't internalized it. She hasn't made any improvements. If the social worker is saying that, you have to have your therapist there to, to testify, to tell the judge that the social worker is incorrect. Otherwise, it's likely that the judge may believe what the social worker is saying, and you may not get that child back at the 6-month review hearing. It's important. You got to strategize with your client. Um, the the hearing is coming up towards the end of next week. I've already been talking to the client. I've already been texting with the client, and we're preparing a strategy and a plan. So you do the same thing with your attorney. Make sure you have all the documents necessary. Make sure you and your attorney know how those documents are going to be introduced into evidence, and make sure that all the necessary witnesses are subpoenaed to court. Yes, subpoenaed. If you ask someone just to come to court and then they don't show up that day, you don't get a continuance, generally speaking. It's just too bad they didn't show up. So make sure that you subpoena your witnesses and they know that they have to come or face possible, warrant out for their arrest if they don't show up to testify. Okay? Listen, this is going to be an abbreviated show. It's Sunday morning. My guest had some technical difficulties. So I'm going to tell you thank you for watching. If you have any questions, go ahead and give me a call, bottom right-hand corner, 888-888-6582. I hope you see that telephone number there. And we will see you tomorrow night on the show live at 7 p.m., Monday through Friday. So we'll see you folks tomorrow night. Everyone have a good rest of the day, Sunday. Bye-bye.